right. Well, he figures out how to find new contestants and not be frustrated about it. Let's go down to Florida, where I hear it's cold. Wade Mercer, first appearances.
I think you're just being brought back today to tell you that the Gaston County warrant has came through, but it's an ROR warrant. Is that right, Corporal?
Yes, sir.
Thank you. So you were held for Gaston County. They have signed a warrant, but it's an ROR warrant, and what it says is per probation office request. So what that means is the probation officer did file a violation against you, but for whatever reason, the probation officer asked the judge to give you an ROR warrant. ROR stands for release on your own recognizance. So what that means is you will not be held for Gadsden County any longer. When you get out, you'll get a court date there. You'll deal with that then. You've got the bond set on the Jackson County cases. You have the right to post a bond. If you do post bond, you'll be released. And then you need to contact your probation officer over Gadsden County. Mr. Wiggins, anytime your bond changes, you have the right to use the phone. Anytime the bond changes, so you're going to get to use the phone this morning to contact friends or family if you wish to try to post a Jackson County bond. Any questions?
Oh, sir.
Have a good day, sir.
All right, you too.
Thank you. Oda Myrick. Oda Lee Myrick. Mr. Myrick, good morning. Mr. Myrick, you're here because the violation of probation warrant came through. I know that you've got bond set on your new charges. The VOP warrant has been signed by the circuit judge. Mr. Myrick, it has no bond on it. So what I want to do you this morning, what I want to do is get you arraigned. I want to get you a lawyer appointed if that's what you're asking for. And then we're going to give you a court date, and then we'll see if you have any questions. Would you like to have an attorney appointed to represent you in the VOP?
Yes.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel, please.
Your Honor, we're going to interview him not guilty. He's got a court date set February 3rd. I suspect they'll take care of it on that date. If not, it'll be March 5th. Nothing else.
February 3rd already has a date. Mr. Mitchell, anything?
No, Your Honor.
Mr. Myrick, you've already got that date of February 3rd, so you should be on that date. And as Mr. McDaniel said, maybe you can get it resolved then. Any questions, sir?
I know.
Have a good day, sir. We have Benjamin Durham. Good morning, Mr. Durham. You're here because you are accused of one count of possession of cocaine. I read the complaint. There is probable cause for the charge. Does not appear to be the strongest case that I've seen recently, but it's there's enough there for probable cause. Your criminal history is not bad. Very little stuff on your criminal history. I am concerned that the pretrial release sheet doesn't show an employment. Are you working?
Yes, sir. I'm working on the side. We're just now starting to, my buddy's starting his LLCs up, doing mechanicing. And we're working, doing decent mechanic work and all that. I'm just waiting to get put on the LLCs.
So how long have you had a real job? How long has it been since you've had a real job? And by real job, I mean 40 hours a week or something close to it.
40 hours a week, maybe like 2 months.
Where was that at?
Or was that at, it was up in Georgia.
Where at?
Box Springs.
Were you living up there?
Yes, sir. I just moved down right after my mom passed away.
Okay. And how long did you have that job?
I've had that job for 5 years.
Okay, that's good. Let me see if the attorneys have any additional information. Mr. McDaniel, anything on behalf of Mr. Durham?
No, Your Honor.
Mr. Mitchell?
We just request to be subject to random UAs.
So the allegation is that the substance, which was supposedly cocaine, was less than 1 gram, and it was allegedly inside a cigarette pack between the passenger seat and the B pillar of the vehicle. Now, the B pillar of the vehicle, is that the vehicle at the back of the seat? I mean, the pillar at the back of the seat?
I
don't know what the B pillar is.
I'm not entirely too
Is that
sure.
what you, Mr. McDaniel, you know where the B pillar of the vehicle is at?
I had no idea. I didn't know what that is.
I used to work in a body shop. I know what a pillar is, but I don't know where a B pillar is.
Car
okay.
expert, Ms. Williams.
So, Mr. Durham, based upon the evidence against you and your criminal history, I'm going to let you pick between a bond and a conditional release. If you like to post a bond, some people prefer a bond. Your bond will be $5,000 cash or surety. But in these circumstances, I'm going to offer you a conditional release. Either way, you would have a condition of random urinalysis, whether you post the bond or accept the conditional release. Either way, you would have that condition.
I'm not trying to
Um,
separate you permanently, but until further order of the court, you're ordered to have absolutely no contact with her whatsoever. You have any questions about that?
No, sir.
Judge Peel, can you hear me?
All right, Bill,
Recording in progress.
Judge
Can you-
Peel,
I don't
I
have my
can hear
phone.
somebody.
Hey,
I can hear you. I'm in the middle of first appearances. I've got one more left.
you're at the
we are
Jackson County.
too.
All right,
We are too. It's bleeding over somehow, Judge.
Oh, I'm sorry. I got you, Judge
I don't-
Mercer.
I don't know what's going on.
I don't either, because all I can see are my attorneys and,
Okay.
are my attorneys both on mute?
We're going to disconnect here and we'll reconnect and contact the IT and see if they can figure it out, Judge, okay? Mr. McDaniel, reconnect
Hey,
just a moment here.
and Judge Mercer, I've got one more that's going to take less than 30 seconds. It's a preset bond, so I'll log off as well here in about 30 seconds, okay?
Okay, all right. Thank you.
Judge
my
Bill,
phone.
will you
Alright,
give me
call.
that bond amount?
All right, well, they sort out that fun tech stuff. Car talk with Dan. The A pillar are the pillars on the right and the left of the windshield. The B pillars are the two between the front and back doors, and the C pillar are along the rear window. That are the A, B, and C pillars of a car. All right, we're slightly in the way back machine here, so let me see if I can bump this forward just a little bit. All right, we might be going now.
And I did
Yes,
community
ma'am.
service as well as paid a fines.
Okay, and I'm not,
When John muted it out there,
So it appears to be coming through your
Hey,
speaker
Judge
system.
Mercer, I can still,
Yeah.
we're still the same way. We're still got you and me.
Okay, I can post it. I just have.
So it means it's not coming through our system, it's coming through the jail. Back to where we were with Mr.
All right, I think they're
Durham.
good now.
Mr. Durham, do you understand your choice between the bond and the conditional release?
Yes, sir.
And which one do you prefer, sir?
It's hard to,
You gotta make a decision.
yes, if I do conditional lease,
You got a question?
You're gonna be drug tested either way, Mr. Durham.
yes,
All right, you want the conditional release?
yes.
Yes. Okay.
We'll grant you the
Conditional release,
conditional
sir.
release. You'll have the standard conditions of release plus the special conditions I've already told you about. I'm gonna ask the
Yes.
jail to give you a notice for your next court date. That'll be
March 3rd.
March the 3rd at 8:30 will be your court date, Mr. Durham. The jail will also let you use the phone in a few minutes to try to set up transportation. If you do contact friends or family for purposes of transportation, you can tell them you can be picked up at the Jackson County Courthouse, the conditional release office, in 30 to 45 minutes is when you'll be there and be ready to go. Any questions?
No, sir.
Have a good day. We have Richard Lyons.
Yes, sir.
Mr. Lyons, good morning. Mr. Lyons, you're here because you're accused of one count of driving while license suspended or revoked. Knowingly, Mr. Lyons, there is probable cause for the charge. I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to your attorney, Mr. McDaniel, and we'll see where we go. Mr. McDaniel,
Your Honor, we just asked for a reasonable bond.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Lyons, based on your criminal history, I'm gonna set your bond at $3,500 cash or surety. You have the right to post the bond, Mr. Lyons. Be aware that you do not have a driver's license. You've got a condition that you not drive a motor vehicle. So if you get caught
Yes, sir.
driving, then in all likelihood, you're gonna go to jail with no bond. Mr. Lyons,
Yes,
you'll
sir.
get a chance to use the phone in a few minutes to try to post that bond. I'm also gonna ask the jail to give you a notice for your next court date, so we don't have to mail you one. And that way we'll know that you get it. And that court date will be March the 2nd at 9 a.m. Mr. Lyons, any questions?
No, sir.
Have a good day, sir. Misty Dykes. Ms. Dykes, good morning, ma'am. You're here in case 23-203 CT. Ms. Dykes, you've already entered a plea of guilty or no contest to this charge of driving in no motor vehicle registration. Looks like, appears I gave you time to pay a fine or come back to court and ask for extension if you wanted one. And according to the clerk's file, you didn't pay the fine and you also didn't come back to court. That's when the warrant was issued. I'm appointing the public defender's office to represent you, ma'am. I'm going to ask that you listen to Mr. McDaniel, please.
Your Honor, I spoke to Ms. Dykes. She's going to request the court to amend the sentence to add a $400 purge. She has 1 day jail credit and She'll have to have that paid in the clerk report. Once it's paid, she'll be released. If not, she'll finish up 10 days.
Mr. Mitchell, any objection to that?
No objection, Your Honor.
Ms. Dykes, any questions about that, ma'am?
Just when can I call?
Right now.
Ms. Dykes, is that what you want to do, ma'am? You want to add that purge?
Yes. Yeah,
I can't hear you.
yes, yes, sir.
Ms. Dykes, I'm going to amend your sentence. I'm going to add a purge on there, which is normally what we do in these kind of situations. Your purge in your case is $400 because you originally didn't have a public defender and now you do. That's why it's $100 more. So it's as soon as you pay the $400, you'll be released. As Mr. McDaniel said, Ms. Dykes, that $400 has to be paid at the clerk of court's office, not at the jail. The clerk of court's office hours are 8 a.m. to 4:30 p.m. So right after first appearance, you're going to get to use the phone, ma'am, to contact friends or family and tell them about the purge. And as soon as it's paid, you'll be released. But if they don't pay it today until after 4:30, if they try to pay it at 5 or 6 p.m., they can't pay it until tomorrow because the clerk's office will be closed. So make sure you tell them that. If you're not able to pay it, you'll finish the jail sentence and then you'll be released. Ms. Dykes, do you have any questions? Have a good day. One day. James Ammons is next. Mr. Ammons, good morning. You're here. Mr. Ammons, for the charge of trespass. Mr. McDaniel has added you to the docket to see if we can get your case resolved. So listen to your attorney, please.
Your Honor, I spoke to Mr. Ammons, 2631 MM. He's going to plead no contest, trespass, understanding he'll be sentenced to 6 months in county jail, 11 days jail credit, $370 fine. He's waived his right to jury trial and call witnesses. He's resolved this case today.
And
How many
that is-
days credit did you say, Mr. McDaniel?
11.
6 months, yeah. Mr. Mitchell's had agreeable with the state.
That is agreeable with the state, Your Honor.
And Mr. Ammons, did you hear that agreement?
Yes, sir.
Mr. Ammons, any questions about that agreement?
No, I do have a question. The agreement, no, I had a question about law. How long,
Could you tell anything about it, Cesar? I could hear Judge Peel and his jail,
Yep.
and he could hear us and ours, but we could only hear him when our jail was unmuted.
I heard Casey Bigelow and Megan Ford too.
So it's,
No other questions, Your Honor.
I'm good, I guess.
all right, so no questions then, Mr. Ammons?
I did have a question. I just want to
Do
know
you
how
still
long.
have a question, Mr. Ammons? Do you still have a question? Mr. McDaniel tried to answer it. If he
No,
hasn't,
I guess not. He won't let me say anything.
he can't stop you from saying anything. If you have a question, you can ask it if he hasn't answered it. Do you have a question?
Yes, sir. I wanted to know how long a verbal warning lasts because
It's,
the place I was at, I was at their house, Christmas. They were
Okay.
out of town. They were out of town and they have these cameras that automatically
let
call.
me answer your question. Let me answer your question.
Okay.
A verbal warning is indefinite, lasts
Okay.
forever, unless there's a time limit given at the time it's given.
Okay.
So unless they
What-
say next 6 months or next year, unless they say something like that, it's indefinite. There's no expiration date
okay.
on it.
I
Any other
understand that with
questions?
no, sir.
I'm gonna accept your plea of no contest to the charge of trespass in case 26-31 MM. I'm gonna judge you guilty, sentence you to 6 months in jail, 11 days credit, $370 court costs and fines. Mr. Ammons, I think you've been in the trustee program before, so you know how it works. I would encourage you to check in that program if that interests you, and I wish you
Yes,
the best, sir.
Thank you, sir.
Thank you, Mr. Ammons. We have Zoe Morris. Ms. Morris, good morning. Mr. Morris, you were first appeared on the charge of battery, it appears, and now you have a hold from the Department of Juvenile Justice. Yeah, what the hold says is that,
Charter to the DJJ, I think. Your Honor.
yeah, it's not actually a hold. What it is, it's a letter from DJJ asking to be notified. So do y'all actually, Corporal, do y'all actually have something? I bet she's already been committed. I bet there's an order committing her to a program.
Yeah, it's Dove, Your Honor. She's been committed to Dove, and that's where this battery happened, was at the facility against an officer there at Dove, and they're asking that she be returned to Dove.
Okay, so you've got to have something from a judge to hold someone, not from a probation officer. So I'm assuming there's an order out there committing her to that program, Corporal. You may want to try to look into that a little further, but it appears, ma'am, that if you do post bond, it appears that the Department of Juvenile Justice is going to have a hold for you because there's a prior order signed by a judge committing you somewhere. Ms. Morris, do you have any questions?
No, sir.
Have a good day.
I will say it looks like more likely if the hold is to come out, it's going to come out of Marion County.
Yeah, she's convicted in Marion County and they placed her in that juvenile facility. That's.
Yeah, they've got to get a hold from that judge, a VOP affidavit or something from that judge, but I'm sure they're working on that.
All right, and we are on the record in the matter of the City of Wyandotte versus Cameron Griffin Short, 19569. Oh, Mr. DuBois must be paying attention. I was just gonna ask somebody to come grab you, and there you go. Thank you.
Always, yes.
All right,
Good morning, Your Honor.
good morning.
There are any other one here on behalf of Cameron Griffin Short, Mr. Griffin Short Station, the records are Cameron Griffin Short. Thank you.
All right, thank you. And today is the date scheduled for sentencing on your client's plea to the charge of loitering or drugs or kept, used, or sold. And the court will note that this was from 2019, and this has been in warrant status for a bit. And then your client is now here to take care of it with the sentencing.
Correct.
And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we've gone over it. He indicates that it is factually accurate and without need of any corrections or additions. The recommendation seems appropriate under the circumstances. You'd like to get this resolved, get this behind you as soon as possible, Judge.
Okay. And sir, if you're to test right now, what is in your system?
Marijuana,
All right. When did you last use marijuana?
approximately 72 hours ago.
All right. Sir, you seem like you're a fairly intelligent individual. Did you read the document that this court gave you with your bond conditions?
Yes, Your Honor.
And so then you read that you are not to possess or consume any alcohol or drugs unless prescribed, correct? And so are you prescribed marijuana for medical reasons?
For anxiety,
You're prescribed marijuana.
I have to renew my NMP.
Oh, well, did you provide this court with a letter from your treating physician prescribing you marijuana?
No, Your Honor. That's how I have to renew the prescription.
Okay. So I'm trying to tell you, sir, that if you have something, a letter from your treating physician, you don't have to go through the steps of renewing your medical marijuana card for this court. However, you don't have a letter and you don't have a valid medical marijuana card right now, do you? Then you're not allowed to use marijuana.
I no longer have access to the letters. No longer have access to the email address that was sent to me, which is why I was trying to get it replaced via NMP, or as I would have to apply for it to let it expire. I have access to the address or the email address in which I received it.
Okay. And I hear all that, but you don't have a valid medical marijuana card, nor do you have a valid prescription from your treating physician. So you're not allowed to use marijuana right now, sir. This court ordered that on November 26th. And you just completely disregarded it.
Apologize, Your Honor.
Did you contact the court indicating that you had medical reasons? Tell me about your 5 warrants, sir. Have you cleared them up yet?
Recently just been able to get to a point in my life where I'm able to do anything. And now I'm taking care of it with full time. I'm now able to, and now since I'm able to work full time, I've been able to trying to take care of my legal matters as I'm becoming aware of my situations that I put myself in previously.
Okay. And so, sir, it appears to be that where you're working, you're making good money, correct?
Yes, Your Honor.
Okay, and you're receiving money to almost $300 a month on a bridge card?
Yes, Your Honor.
You work about 40 hours a week, sir?
Give or take, Your Honor, yes, that's all I have. get me on schedule between 36 and 40.
So it's interesting, sir, that you've indicated that you need marijuana for anxiety because you've reported that you're not under a doctor's care, you're not taking any medications, and no history of mental health treatment.
I have not been under the care of a doctor for marijuana since I was 18 years old. I used it as I was prescribing it because I declined Zofran, other Zoloft and things of that nature, because I don't feel as if I have a mental health disorder from using marijuana. So I feel the need to list that down because I'm not prescribed on any actual drugs such as Zoloft or serotonin or anything of that nature.
Okay. Well, if you are diagnosed with anxiety, sir, that's something that we should need, that we would need to know.
My apologies.
All right, council asks for the recommendation.
Your Honor, I recommend under the circumstances.
All right, the court does find after hearing from counsel, hearing from Mr. Griffin Short, reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court's going to order the following sentence as it finds the sentence is in the best interest of justice, is reasonable, proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Griffin Short. The court's going to order 12 months probation. You're eligible for early discharge. I'll go over that shortly. You're also eligible under 771.1 status. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. Sir, that applies for marijuana. So
Is there
we have a treating physician.
if I get my new treating physician, as I currently don't want to take any Zoloft or anything of that nature, can I still use my marijuana now? Because I use it I talk on the phone for 16 hours a day at times. I cannot go without it. I'm not gonna lie, I just can't survive without it. My anxiety is too bad. I'm shaking right now because I'm scared. I didn't smoke today. I haven't smoked in 3 days. Can I get a letter for it? Because otherwise I'm gonna be in jail for smoking weed.
Well, hold on, sir. If you were to be in jail, it wouldn't be for smoking weed, it'd be for not following the court's orders. Okay, so let's just be clear on that. Okay, there's nothing funny about that.
It's not funny at all, but I'm asking what you prefer for me to take Zoloft.
Sir, I would prefer for you to utilize the medication that your doctor, your treating physician prescribes. If that happens to be marijuana, okay, that's marijuana. What this court will not accept is if you're walking into a marijuana clinic for a doctor to just prescribe that doesn't have any knowledge of you, your history, anything, sir. That is what this court will not accept. So if you have a treating physician, or if you're obtaining a new treating physician because you don't see eye to eye on your medical treatment with your current one, then that will suffice. But not a medical marijuana clinic doctor. Because you see that one, 2 years later, you go back and see him again. You don't have any follow-up appointments. If you're using marijuana for medical purposes, right? It's medication. You have to have follow-up appointments with your treating physician to ensure it's working properly, just like with blood pressure, with diabetes, things of that nature. If it's medical purposes, you need to have follow-up, you have to have follow-up appointments.
That's not as docket and the medical procedure goes. Y'all know what I understand.
It's not a what is it? Not
the medical docket. It's not the procedural of it, but I understand where you're coming from, so I follow your guidelines.
okay. It may not be the procedure for medical marijuana, but with this court has discretion, right? And so the court's not denying your use of marijuana for medical purposes, but this court has the discretion and the authority to set parameters to make sure that the marijuana is specifically for medical use. And that is one way that this court can ensure to the best of its ability that it's for medical purposes and not for recreational under the guise of medical purposes. Got it? Need a verbal yes or no?
Yes, Your Honor.
Okay, the record doesn't record nonverbal responses. The court's going to also order you to participate in the chemical awareness program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use so you can make better informed decisions in the future, hopefully preventing this matter from happening again. The court's going to also order you to clear up your warrants. I'm not going to order any workforce today. You're to clear up your warrants. Any questions on those conditions?
Oh, Your Honor.
The court's going to order a $100 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, chemical awareness program of $75. That's a total of $1,300. You're going to go over to probation, sir, and you're going to set up a payment plan. And then you'll get your next steps for your instructions, okay? As I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay?
Yes.
All right. Good luck to you, sir. Have a good day.
I'm going to have some stuff to say on this one in hour 4. I'm annoyed. Let's, Texas, Judge Stevens.
Everybody checks off the boxes, but James, he colors them in. Which is kind of neat. I like that. It's
my trimmer in the morning.
It's coloring. He colors it in, which is pretty neat. I like it. I like that.
Yesterday, I had a client come in and he said, well, I have a central premise. And I'm like,
Well,
so do I. And then he stood up
I
and
got
got
him
to
from my
sign his
mother.
name and he's literally doing this.
Oh, he had them.
And I'm like, oh,
You got them from you?
no, I don't.
Oh.
No, he's had them for years. And then I said,
My right hand.
yeah, whatever
is
I get.
my mother from my mom. God bless her.
You know,
I got worried growing up, and went, he says, no, you don't have any problems. Does your mother have? Yes, she's got the same thing. Well, you've got it.
genes, yes.
Genetic code, you gotta love it. Thank God, but I'm left-handed, so I don't have that problem with my left hand. It's always been one.
You know, everything I've gone through, they discovered I'm missing a gene, so I have to wear this thing. I'm on some kind of anticoagulant medication.
Wait. You're the missing link?
Yeah, I'm missing link.
You're the missing link.
You know, I've had 3 blood clots and all. The nurse goes, oh, people normally don't survive too. And I'm like, oh boy.
So it sounds like you're out to set a record.
Yeah.
All right. Well,
So I
good luck.
I take my medicine religiously.
Anyway, here we are in 25 CR 989, the state of Texas versus Charles Edward Amburn III. That's you, sir?
Yes, sir.
Present with Mr. Macon, your attorney, and the state's attorney. Does the defendant, oh boy, waive a full reading of this indictment? Can we instead proceed by summary?
Yes, Your Honor.
In summary, Mr. Amber, paragraph 1 of this indictment alleges that on or about May 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. DWI. Do you understand what you're charged with there?
Yes, sir.
If it only ended there, you wouldn't be in this court, you would be in a lesser level court. But paragraph 2 goes on to allege, and this is disturbing here, that you have 4, not 2, and it only takes 2 prior DWI convictions to make a 3rd-degree felony for the 3rd one. This is from what I understand, at least your fifth one. And that's too much. That's too much. It states that in 1985, you were convicted out of County Court at Law number 3 for Jefferson County, Texas, for a DWI. December 15th, 1988, 3 years later, you were convicted out of County Court Law number 2 of Jefferson County, Texas, for a DWI. 10 years later, in 1998, you were convicted next door in the 252nd Criminal District Court of Jefferson County, Texas. That was a felony then. And then in 2014 here, in my court, the court I preside over, it's the People's Court, the Criminal District Court, you were convicted of another third-degree felony of a DWI. So you have been subject to third-degree felony punishment, well, since 1998, 2 convictions ago. This is disturbing. Would you agree? Can you hear okay? Because I couldn't help but notice that you were having a hard time listening to the lady here, my coordinator. Man, you're having a hard time listening to me, and no one ever thinks I speak softly. They think I speak sometimes in a booming voice sometimes. But
Your Honor, if I may.
Generally, the first felony stops people from committing this crime because they don't want to go to prison. But this is happening too often, sir. Let me read this. He said the policeman that he had 1 beer. What was the blood test? I don't have any information on it.
0.235.
0.235, 3 times the legal limit. That beer had to have been 5 gallons, a 5-gallon beer, at least. That's 3 times the legal limit, 3 times too much. Do you understand what is charged here in these paragraphs of this indictment?
Yes, sir.
This constitutes a third-degree felony, sir, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. Again, I think this is probably the 3rd time this has happened. Then that would be suspended. You would be placed on regular probation for 10 years. Fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. And then I see here is a recommendation of 20 days in jail. You've been twice ordered to do 10 days in jail on the previous convictions.
The one from 2014, Your Honor, it was, he was actually convicted of a lesser included, Class B misdemeanor on that one.
Say it again.
The October 13th, 2014 cause number 13-17984. He was actually convicted of the lesser included Class B misdemeanor.
So what happened there? Why did that happen? After, that was his fourth conviction. So he only has one felony conviction out of the 252nd?
That's correct, sir.
Why in the world would that have been reduced? I'm surprised MAD didn't come, which is what they take care of. I mean, and I support them 100%. You don't get lesser exposure to criminality by committing subsequent similar crimes. The punishment supposed to go up. Anyway, you have 2 or more prior DWI convictions. So this constitutes a 3rd-degree felony. And you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. And I read what the plan was. It's essentially 10 years in prison, probate that for 10 years. And there would be terms and conditions of probation, which were similar to the other 4 probations I presume you were on. Were all these probations, or did you just do time on some of these misdemeanors? Do you remember?
You remember if you did time?
You had the prior convictions, right?
Yes. Sure.
What does it show, please?
I did. Mistake? Yeah. I did, on the 252nd, Mr. Giblin, I did 7 years probation. I did, intoxilizer in my truck, Smart Start for, 7 years and 300 hours community service. And, the last one I got back in 2013 or 14, it was 2 years probation and several hours, 100 hours, I believe, for the community service. And a couple of $2,000 fines, sir. And I completed the probation both times in the community service and paid my fine. And I had the intoxilizer the second time. The last time I had one, 2013, I believe it was. The final disposition was in 2014. I think I got the DWI in 2013, but the final disposition was in 2014. But 2 years probation, and I had the intoxilizer for I think 3 years, sir. I've got an intoxilizer in my truck right now.
Well, that was a condition of bond.
Sir?
That was a condition of your bond.
Yes, sir.
When you were arrested this time.
Yes, sir.
But it's not because you wanted to do it. It was because it was ordered. And so this is at least, we're dealing with your fifth DWI this time. Correct? This is your 5th one today.
Yes, sir.
Well, do you have from this?
Yes, Your Honor. He got 20 days on one of the misdemeanors,
Which one,
60
please?
days. That's County Court at Law number 311. That was from 1985.
Okay, that's the first one here of the 4.
April 1998. That's in.
No, that's just, where's 1988's conviction? Out of County Court at Law 2. 137400.
20 days in 1988.
You got, and in 1998, 7546, the 252nd.
7 years, probated for. And probated for a term of 7 years.
I guess he had to spend some time in jail. That's
Yes, sir.
a statutory required 10 days.
Something.
Think so. Yes, Paul, you today.
There's two kids that are the same age.
I took the Evelyn Manning speed reading course. Would you like me to have to read that one? I know it's a packet. of
10
stuff.
days.
It's always a packet of stuff.
10 days, jail.
And then we get to the 2014, and that was reduced to a misdemeanor. And what did he receive?
Suspended. He received a 180 days jail that was suspended, and he was placed on community supervision.
There was a requirement, I think, if it's a misdemeanor, then at least 3 days.
They're normally giving credit for that.
Yes, sir. Oh, they don't, they actually don't go into jail, they just give them,
Sometimes they do,
really?
but if they have a good lawyer.
Well, I mean, it's a mandatory 3 days, how can they get credit if they didn't serve the time? Uh-oh, you're
When
looking
they, when they get arrested.
at, that's one,
One. I think it counts.
they counted for 3. I'm not sure that the people who are advocates of this, against this kind of behavior, I feel like that's fine. Because I got it's good. All right, is that, okay, all right, so again, you're looking at a 3rd-degree felony, and you would be found guilty, sentenced to 10 years in prison, that would be suspended, and you would be probated for 10 years, $500 fine. You understand that all of this?
Yes, sir.
If I follow this agreement, placing you on probation for, I guess, a 5th time?
That's a great question.
Is that right? Is he on probation on all those others?
That's correct.
Then you have no right of appeal of your case. Do you understand if I follow this agreement?
Yes, sir.
How do you plead this guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which recites 4 prior convictions of operating motor vehicles while intoxicated, 4. And at least one of them being a felony out of those 4. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true voluntarily? And because these allegations in this indictment are all true and correct?
That is true, sir. Yes, Your Honor.
If I make it a misdemeanor. Then criminal mischief and this is law. This mayor have a real constitution. Issue is.
You want to show you what marked the State's Exhibit 1? Did you sign that document? Understand it? Discuss it with your attorney. Are the contents all true and correct? Is everything true and correct there?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objections.
And without objection, it's admitted. Hold on, I'm gonna let him look at one other thing. And on this page, is all of that true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence, and without objection, it's admitted. Among other things, sir, This states that you are mentally competent to enter your guilty plea.
Yes, sir.
You have a little hearing trouble, but I think you're alert mentally. You understand and appreciate the consequences of pleading guilty. You were competent to enter this guilty plea. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle while intoxicated. As I find you are mentally competent to enter your guilty plea, it is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. And there's sufficient evidence here supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. Pre-sentence report is waived, I presume.
Yes, sir.
I follow this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison.
Sure. Oh, actually. Federal.
You must have an auto ignition interlock system in any vehicle you operate, which requires you to pass the breath test before it will start. You must complete a Texas DWI repeat offender program. We're about to go into that. Yes. Everybody buckle up. You're gonna go to jail for a while. This is your fifth DWI. You have been placed in jail 4 separate times before, and you are still out there driving while intoxicated. It's a 4,000-pound missile. It has to be operated soberly and responsibly. And 3 times the legal limit is not responsible behavior. You're asking for when I assess this to do it on weekends. Why is that?
Your Honor, Mr. Ambert is employed as a rigger, gainfully employed, and would ask for the weekend time so he can take his job.
All right. Anything from the state? Because I'm about to drop it.
No, Your Honor.
180 days. You can do it in successive weekends. It'll take forever. But at least you won't be on the roadway putting people in harm's way. You have had the 4 previous convictions did not deter you. And we're just lucky that somebody wasn't, if there wasn't an accident where people were injured or killed. This is irresponsible behavior. And I know the judges have talked to you in the past, but you're still doing it, sir. Are you an alcoholic? I'm going to be right frank. Are you an alcoholic?
Under the definition of alcoholic, yes, sir. I believe.
What are you doing about that?
Well,
What are you doing to help yourself?
I have not had a drop of alcohol since the day I was arrested in May 17th.
You have been.
It's 8 months.
No, but you've been dealing with DWI charges and convictions since 1985. That's 40 years. 40 years, and you still are not getting it right. The most I can assess is 180 days. You seem like a nice person, but 250,000 people in this county need to be safe from irresponsible behavior like this, repetitive. So you're going to do 180 days. And that's going to take a long time. You're going to have to report in the jail on or before 6:00 p.m. every Friday. They will release you 2 days later so you can be able to work. You're talking about, at that rate, 90 weekends, almost 2 years, every weekend. But I really don't feel sorry for you. I'm here to be fair and impartial, but also see what's in the best interest of the people and their safety and well-being. And you're not. I'm really considering just ordering you not to operate a motor vehicle on my watch. Which I think I could do. I don't see anything in the Constitution that states you have a right to drive. But shame on everybody involved the next time this happens. Because you have shown a propensity to continue to do the wrong thing. And it's all about your self-interest. You know, everybody else is put in harm's way, but you're getting high and getting intoxicated. You're not putting others ahead of you like you should. You're just concerned about your inebriation first. Getting high, getting inebriated. Everybody else is going to be in the way, and they're the vulnerable ones. You can't think that. It's selfish thought. I don't think you're a selfish person, but you are portraying yourself to be for 40 years. Anything else?
When is the jail time to begin?
This weekend.
That's the 30th. Friday the 30th.
Whatever it is, day after tomorrow. Today's 28. Yeah. Do you attend an Alcoholics Anonymous program? You're going to. I'm going to throw you in that too. That's important. I think they're helpful. But whatever has happened for 40 years is not working. And I don't want a catastrophic fatality event happen on our watch, because that's what happens when a 4,000-pound missile hits another car. Like this can happen. All right, Mr. Amber, please see the probation officer. He will go over everything and we will begin probation.
All right, good morning once again. We're here for the sentencing in People versus Robert Lee White, 252284. Good morning, Mr. White.
Good morning.
Mr. White was here in a timely manner reading. The attorneys have been discussing the matter. Present is his attorney, Ms. Casey Strong, and Abby Stoll is here from the prosecuting attorney's office. This is a FY case, which stands for a felony. It started as a larceny over $1,000, but less than $20,000. This allegedly occurred in the summer of 2025. The defendant was arrested in November of 2025. The felony charges were dismissed, and the defendant entered a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. That was done on December 16th. This alleges a number of thefts of wire and other property that belonged to Forest River. There are apparently videos of some of this, and there's some other evidence. There's a co-defendant, Peggy Lytle, who has yet to be arrested. There's an open warrant for her arrest for this same set of circumstances. At any rate, Mr. White entered a plea and the matter was set for sentencing. It was set for sentencing on January 21st. And the defendant called and said, I can't get to court. The person I'm writing with has a diesel truck. It won't start. It was very cold that day. Schools were closed. The roads were bad. We simply agreed to continue the matter until today. It had been set for sentencing. Well, earlier in December and early January, we were trying to determine what the restitution amount would be. So the matter was adjourned from the 21st to today, the 27th, and here we are. Joining us now is Angelique Camfield from the prosecuting attorney's office. And she was attempting to get more information regarding the restitution issue. And it's hard to determine because there were more than one incident. It's hard to value this property. What is its value is for its intended use, or what is its value for scrap? Those are issues that could make restitution difficult to nail down. At any rate, as I indicated, Mr. White entered a plea on December 16th. I talked to him about it. He acknowledged responsibility for this, told me that he stole this property. I'm advised this morning in chambers.
I wasn't aware that I was stealing, sorry.
All right, that you wish to withdraw your plea.
Yes.
All right. You told me you knew you were stealing. I don't know how you would not know you weren't stealing.
There was no signs or anything, Your Honor, and the guy that told me about the place said he's been getting wire from there for over 2 years.
Your Honor, I just want to do a blanket Fifth Amendment. If this is going to be withdrawn, I want to make sure Mr. White understands fully that we are recording and anything he says could be used as an admission.
So, yeah, so don't say anything. The problem is it wasn't yours. It doesn't matter that other guys were stealing from it. It wasn't your property. Stop. And it had value or you wouldn't have taken it. So apparently there were multiple incidents of this, but the upshot of this, Mr. White, the felony charge was dismissed in exchange for your plea to a misdemeanor. Are you advising me this morning that you wish to withdraw your plea and have this matter set for a preliminary examination on a felony charge?
Yeah, Your Honor, because I don't see where there was a crime committed, really.
All right.
It was more of a...
Don't say anything more. I'm not unwilling to hear what you have to say, but as your lawyer says, anything you said could be used against you. The law in this area, we discussed this in chambers, whether I agree or not, the law says that when someone moves to withdraw their plea prior to sentencing, the court shall grant that motion to withdraw the plea with great liberality, meaning the law favors allowing the defendant to withdraw the plea. Whether I think it's a wise idea or not isn't part of the equation. You're turning a misdemeanor back into a felony. And what would the next step would be to set a pre-exam conference and then ultimately a preliminary examination. Ms. Canfield, were you able to get any restitution information?
I did get some restitution information, Your Honor, and they're in the process of gathering the documents in support of that. But what I can relay to the court and counsel is that I spoke with Mike Getter, who is one of like the main general managers of the company, and he then has the subsequent plant managers that oversee things. The purchasing agent for the White Pigeon plant is Dorothy, and Dorothy was gathering some documents for the alleged drum of wire that was stolen, some receipts for their scrap metal that when they turned it in for money, they earned $1.26 a pound. And she says each drum, if you will, was 600 to 700 pounds. And there were 9 of those that had been taken over the course of these few weeks. There was also an entire drum of new wire that was taken, which was presumably something the company would use throughout the business. So that was not scrap. That was $1,702. And then they allege that power cords were taken. I think the defense would be able to point out that in the video, there aren't any power cords in the wagon. There are none that were demonstrated for the defendant to be near, at least on the one occasion that it was videoed. But what the defendant turned it in for, and the receipts that are in the police report indicate that he earned $4,243 off of what he had taken and turned in. So that is the very least amount of what restitution would be, is what he had earned off of it. But I do believe it could go upwards of $14,371, depending upon the court's determination of it after a hearing. The plant manager, for what it's worth, for the defendant and his counsel, had indicated to me that if there were a sanction and a jail sentence, while they would like the restitution back, their main concern is for somebody who is a repetitive theft from their property. They would like some jail, and they may be willing to forego restitution for a jail term. So I just wanted that to be on the record. Because, I mean, if a plea is withdrawn, we will not be making any more misdemeanor offers, and this will proceed as a felony. And I will try it as a felony. So that is the one caveat for the defendant that's important for him to know, and I know the court's already mentioned it.
And for the sake of the record, I did discuss that in the abstract with Mr. White, because it had not been officially extended, but we had that conversation as well.
For the record, the guy stated that he did not care about the wire that I was taking.
All right. So some unknown person, apparently somebody cares about it. So do you wish to withdraw your plea?
Yeah.
I would just state, the court will, for the people, we obviously want to just object to that based upon the fact that there was no error in the taking of the plea. The defendant read his rights, he understood his rights, he had representation. The court was very clear in its taking of the plea. The defendant admitted the offense. And the other portion is, so if there's no error in the taking of the plea that mandates a withdrawal, there has to be a manifest injustice. I don't believe that's been demonstrated by the defense. And I do think also, I don't know that there'd be prejudice to the prosecution necessarily, Your Honor. We have the witnesses available, so I don't know that that element applies.
Well, I don't know about the manifest injustice standard, but yeah, there is a prejudice to the state. For example, let's say this was a plea that was taken on an assault case. And after you entered the plea, the complainant was killed in an automobile accident. And they would be unable to present the complainant.
Well, I feel that there was no.
Stop. I understand what you feel. I don't agree with it, but I understand that's your cockeyed theory of it. My sense of this was a giant gift. The amount stolen is at minimum $4,000 and up to $14,000. If you want a felony, I guess you can have one.
May I say something, Your Honor?
All right, I may stop you, but yes.
I've been in here several times. I've always stepped up, take responsibility for what I've done. I don't feel that, I know for a fact that I didn't take no power cords out of there, and
Well-
I didn't take no big spool of wire either.
All right, one of the things, a lot of stuff was stolen, and you may not have been the only person stealing.
Yeah, I just, in the,
They've got some issues regarding that, but the other issue is your counsel had met with you, advised with you in good faith, and worked out this misdemeanor plea to your advantage, and now that the sentence is nigh, you wish to withdraw your plea. It's not fair for her to have to continue to represent you in this matter. I will release
I understand that.
Casey Strong as attorney. I will allow you to withdraw your plea. As I said, this was in my mind, a generous plea offer. It would be something they could try. The problem is they got a bunch of other much more serious cases than this that need to get tried. And so sometimes you have to make a decision and resolve the less serious cases to make room for the more serious cases. So this doesn't trump a murder case or assault with a hammer or a criminal sexual conduct case, the kinds of things that are pending. So, but you do have an absolute right to have a trial. Where are you living?
Staying in Sturgis.
Are you at the Maple Street address?
Yeah.
Are you really, or just sort of homeless?
I don't know. It's my dad's place.
All right. I would have just set it for a prelim, but we're gonna get new counsel. And it wouldn't be fair to them to appoint it and just set a prelim. So I'm gonna set a pre-exam conference for February 10th. At 8:30. And a preliminary examination for February 17th. At 1. So we're back to square one. We haven't accomplished much between December and now. One of the things in here is you denied everything. Peggy Lytle admitted everything. According to the affidavit, she says, yeah, we understood they were stealing stuff. How many times they stole what?
She told him that we.
All right, stop. So you denied anything, knowing anything about anything. You didn't say some version about, hey, some guy told me I could take this. You just denied it altogether. And then she said, yeah, we've been stealing this stuff. They were out here 2 or 3 times this week. So she hasn't been arrested yet. I don't know where she is. I don't know if anybody's even looking for her. But as I said, if you want a felony, I guess you can have one. You can go to prison for this. As opposed to a jail sentence, but you've stated your position. So we'll set a pre-exam conference for February 10th at 8:30. I suspect your new lawyer is going to tell you the same thing that Ms. Strong told you, that this misdemeanor plea was a good offer. But we won't proceed with the sentence today. In the meantime, the prosecutor will continue to work on that restitution figure. So I want you to go out to the counter. We're going to appoint a new lawyer for you, set a pre-exam conference for February 10th and a prelim for February 17th if needed at 1 o'clock. I'll do an order allowing the defendant to withdraw the plea and allowing Ms. Strong to withdraw as counsel.
Thank you.
All right, thank you.
Thank you, Your Honor.
Anything anyone wants to add from here? State?
Nothing. From
I think we're gonna move forward one way or the other. We've had enough time to figure this out, and if we're not gonna get help from Louisiana officials, there's nothing we can do. We can only take care of Texas. So what says the defense?
Judge, just, I think Ms. Stafford may want to speak to us in a few seconds, but I was wondering, so she did plead true 1-4, without a whole lot of fanfare. She came in and owned up some stuff. One of our initial settings with the court. Since then, we've been trying to work this out with some court conditions that the court imposed. She complied with rather quickly. The state hasn't been able to verify some of the information, but she does, from what she is telling me, have some plans with MHMR and Spindletop to where she could, if she were to be able to get out, get reinstated, she could go there, get the help she needs. Apparently housing, GED, place to work and whatnot, that she could take advantage and start paying back the restitution that the court has ordered on the underlying cases. She knows she made bad decisions with her probation status, with some drugs and whatnot. But some of that was she was transient and didn't have a home.
How much was paid back on restitution, if any? Nothing.
But she was homeless, Judge, without a job. And so if she could get help with getting a job, that might lead.
Didn't stop her from committing a burglary. Didn't stop her from using drugs. Didn't stop her from failing to report. Come on. I mean,
She has been doing well, and she has been incarcerated. She's clear-headed, hasn't had to worry with drugs. I think she's seen the.
I agree. I think
She's seen the error of her ways, and she's.
Incarceration seems what's best for her and her actions. It seems certainly has not proved to be a harm to the general public, except for the costs of the taxpayers to house it. But it's incarceration that keeps her from using drugs, and we know where she is because she doesn't report when she's supposed to. She's been on probation since July of 23, and that's 2.5 years. It's failing. She's had a fair opportunity. Question is, what do we do? And I hear you want to continue on probation. What's the state say?
Your Honor, she still owes the $23,835.
She hadn't paid a dime.
No, sir.
So, I mean, keeping her out for 2.5 years has resulted in nothing except her spending whatever she can for buying drugs that she's tests positive for: meth, amphetamine, ecstasy, and marijuana.
Just obviously leave it to the court for whatever you think is appropriate for that amount of restitution that's still owed and has not been paid in this case.
Can't you see? Yeah, it's hopeless under these circumstances. If not one penny has been paid in 2.5 years.
Judge, would you like to hear from Ms. Stafford?
Yeah.
Judge Stephen, I know it don't look right. It wasn't right what I've done.
No, it's not. It's clearly wrong. You committed a crime. You committed crimes while you were on probation in the drugs. You bought drugs, used drugs. That's all crime. Every one of those are crimes, felonies. Some of these are felonies. Methamphetamine possession is a felony, for example. And you didn't report. You scampered off. You went AWOL. We can't help you when you scamper off and disappear. That's the one thing you have to do. If you can't do anything else, is you've got to report regularly, or else you're really not on probation. You're on your own probation, which is failing. Your probation, while you supervised yourself, you went out and got into drugs. So
If you give me a chance to vote.
I gave you the chance, ma'am, when we placed you on probation the first time. How many chances do you get? How many chances? Everybody is subject to the same thing. We told you hey, as you know, the actions have consequences. And if you violate your probation, only one violation is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced up to in this case, up to 10 years in prison, even though this was a second-degree felony. You were placed on regular probation, so the cap is 10 years, even though it would have been up to 20.
Can you just give me a chance to fight for
You had your chance. I opened the door for you. I opened the door for 5,000 people. Everybody swears that they're going to do the right thing, and 93% of our probationers do. They don't come back and try to explain where they get their drugs, how they got their drugs illegally, committed crimes, and they report. When you don't report, you're AWOL. And I'm going to set an example. They have to follow the rules. If I didn't, then if I treated you differently, then people would say, yeah, I didn't report, but I want the Lydia Stafford rule. She didn't report, and then when y'all caught her, then she got another chance. That's what I want. You are fair, aren't you, Judge? Well, I want to be fair. I'm going to treat everyone similarly in the same situation. You can't go out and go AWOL for all this time. You can't go out and use drugs and then say, okay, I'm going to really follow the probation this time. You've had your chance, you know. Let me see the pre-sentence report if you would be so kind. Thank you.
Nothing cases.
Oh, yes. And you were originally charged with 4 separate burglaries of homes, and the state proceeded just on 1.
No, Your Honor, she's on probation for all 4.
All 4?
Yes, sir.
Okay, hold on. So, all right, then I misspoke. We are also dealing with 23 CR 342 probation, where you were placed on 10 years imprisonment, probation for 10 years. 343, 23 343, another burglary, sentenced to 10 years and probated for 10 years. And finally, a 4th burglary. So you were on probation for all 4 burglaries, 341, 342, 343, and 360, correct?
That's correct.
Well, we need to go through all those.
There's some motion touch.
Well, I know, but she has to enter pleas of truth.
I think she entered.
I believe she did before you. That's what I have it on my sheet, Your Honor. That each one of them she pled to.
Okay, and each of those, you're right. She did enter pleas of truth back on October 6th to the same failing to report any use of methamphetamines. Which case is it that is the restitution?
There was 0341. There was $14,700.
I'm sorry.
03.
So I've got my pen now. Go ahead.
And
Start over from the beginning.
Okay. And 341, it's 14,000.
Hold on. Stand by. Yes. Hello. Yes. Yes, sir. Thank you. What do we need to do about that? What do I have to do about it? Yes, it's where on the water tank, where's the water level? Show. There's a device on the tank that it's a level. Okay. Okay. All right, so, who is it, Johnson City? You would recommend? Gave us. What about Blanco? You know anybody? Uh, Yes, sir. There you go. All right, well. Yes, sir. Okay. Yeah. All right, but thank you for turning out where we're still. What was the level on the propane? Okay, so it was low. Okay. Well, I'm glad we saved it. So, okay, now, I appreciate you so much. Thank you, sir. Okay, well. Okay, we're back here, and that is correct. The defendant had entered pleas of true to allegations in each of these four cases, to allegations 1 and 4. And which is the case that has the restitution on it?
341, there is $14,700 in that case.
How much?
14,700.
Okay.
And then in 360,
yes,
there's $9,135. It's $9,135. And the total that I have is $23,835.
Okay, good. Thanks.
Yes.
All right, anything else to add from anyone here?
Judge,
Go. Yes.
I get the sense of where this is headed, so just making the argument that Mrs. Stafford has been entirely compliant with everything the court has requested of her up to this date. She has been trying.
No, she has not.
Well, since
She submitted
the revocation.
Those are all serious violations.
Yes, sir. And she pled true, and the court had requested some information from her. She provided the court with information. The state had yet to verify it. She did admit she has a drug issue, which I tend to think mitigates these cases. And as such, if the court is not going to reinstate her.
It's not the truth. It's not. There isn't a condition that you can't use drugs. Yeah, there is a condition you can't commit crimes, and these are all illegal acts. These are crimes that you're committing, not just I'm taking medicine or controlled substances, but it's illegal what you have done. It certainly was inappropriate not to report. If you can't do anything else, you have to report. That's the basis. If you don't report, you're not on probation, but I've been over that. You just failed, and I'm sorry you did, but I'm sorry for the victims of the burglaries. That's the victims here. You're the ones you're the one who invaded people's homes, and we gave you a chance, and heck, people can get shot for doing that.
Can I just get a chance to get my?
You had your chance when we put you on probation in the first place, ma'am. And here we are with a motion to revoke probation alleging not one, but 10 violations. We've already Unless. Yeah, we warned you at the beginning, and I know the probation officer is helping as best you can, but. Anything else? I'm sorry, ma'am. What state say?
Again, Your Honor, just whatever the
What
court
are you
thinks is
asking for?
appropriate for this amount of time. Generally, with that amount of restitution, the court has given the maximum from what we dealt with. So that's we'd have to ask for, Your Honor. We'd ask for the maximum. That's what the court generally gives when there's a large amount of restitution that does, and it does sentence someone to a penta.
Okay. Anything else?
Judges said the staff would ask for the minimum. She has been compliant since this has been filed. She's been trying to do better. I think she has an earnest belief that, or earnest effort to try to do better. Drugs did cloud her decision-making and made it more.
It wasn't the drugs, it was her choices that fouled up. Here's what we're gonna do, Ms. Stafford. In cause numbers 23 CR 342 and 343, the court finds that you have pleaded true voluntarily, knowingly, intelligently, and also in cause numbers 341 and 360, you have pleaded true to allegations in each of these cases, to allegations 1 and 4, voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater, and your probations are subject to revocation. I am hereby revoking your probations for your violations of probation in cause numbers 23, 342 and 343. Your probations are revoked in those cases, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with these cases, which should there's just at least 340 days, and that will limit the time you're going to be in prison. It will limit it. In cause numbers 341 and 360, the court finds that there is enough evidence to revoke your probation in those cases. I am going to nonetheless continue you on probation on those two, so that you can pay something back to these poor people who I feel sorry for. You still owe restitution in the amount of $14,700 in cause number 341, that burglary of a home, and restitution of $9,135. You're going to continue probation. If you fail on those, you are subject to, as you know, revocation and 10 years imprisonment on each of those cases. Don't think I won't assess that if I feel like you are not trying. You have been on probation for years now, and you have paid nothing back, but you have gotten into drug trouble again, and you have walked off the job and failed to report. That's irresponsible. You have to pay a price for that, and I'm holding you accountable. Anything else to add? That is all. Thank you.
Thank you. Francisco Elijah Cantu, 25F2447628.
Good morning, Your Honor. Mr. Chairman, may I have my kindly questions?
All right. Mr. Cantu, your name?
Francisco Cantu.
All right. So your client, Mr. Shemke, pled no contest operating while visibly impaired. There was an accident here. He was referred for a screening and assessment. But before you go on, I need to make sure, Amy, that there's not a Timothy Roberts out there, either in the courtroom or on Zoom. He was notified he is the victim. Anybody out there?
No Timothy Roberts on Zoom.
Thank you. Have you had a chance to review the report, counsel, and are there any material additions, corrections, or deletions?
I have, Your Honor, it's factually accurate.
Anything you'd like to say on his behalf?
Yes, Your Honor, my client's done extremely well on bond. He still had gainful employment. I looked at terms and conditions. I do believe they are appropriate. I believe he could put himself in a very favorable position for early termination. That being said, Judge, he works somewhere between 55 and 65 hours a week and more. I potentially just ask consideration for as an alternative to the workforce for community service, but otherwise, I believe all those conditions are appropriate. And I have no further requests. Thank you, Judge.
Sir, anything that you would like to tell me before I sent you?
No, Your
And this is your first contact, but you're only 22. This kind of scares me that you're here already. I was telling you. You understand?
Yes.
Okay. All right, 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to appear as directed. No alcohol at all. You're not to purchase, possess, or consume any. No marijuana, no illegal drugs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs. They're recommending, it appears, bi-weekly throughout. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll make it monthly. So make sure all those tests come up negative, okay? You understand? You're to attend the Substances Abuse Group through Class A Training Center. You're to attend the Victims Impact Panel. This does no contact with the victim at all. I'm going to order 4 days jail, credit 1, serve 3. I'll let you do one of those by way of community service, but the other 2 are going to have to be done on the court work program. 1 day community service. I'll give you until March the 15th to complete that. 2 days on the court work program. There's a $35 a day charge for that, for a total of $70 in court work program fees. So far, do you understand the sentence?
Yes.
Okay. This was a intoxilizer, correct, counsel?
Yes, Your Honor.
So I'm going to give them cost of recovery of $150, $300 in fines, $250 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $675. Cost of recovery is $150 for 8 1/4. Screening fees $60 for 885. Probation fees are $240. So your total there amounts to $1125 plus the court work program fees. Your total is $1,195. If you violate, your probation could be revoked. You could be eligible. You could be incarcerated for up to 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Also, you may be eligible for early discharge. You stay out of trouble, no violations. You come in here in 6 months. You fill out a petition. By law, you're entitled to early discharge. Okay? You understand all that?
Yes.
All right. Does he have all this to pay, Mr. Shemke?
Do you need a payment plan? Yes, Your Honor. I'd ask that,
You can pay it all?
in this circumstance, Judge, I'd ask that, if he's eligible for early termination, his balance would be paid minus the potential extra 6 months of supervisory.
Well, we'll return that.
Okay.
Man, you gotta take that phone out of here.
The phone has to leave the building, ma'am.
Ma'am.
Phone has to be out of the building.
They give you that phone?
Yeah.
Who's they?
Who's that?
In the door.
All right. We will refund that if he's granted early discharge. Okay, sir, you're gonna meet with the probation department, okay? Go down, pay your fines, and then go over to probation, and they'll instruct you.
Thank you, Judge.
Thanks a lot. Have a good day. Holly Darnell. Holly Ann Darnell, 25T647138.
Good morning.
Good morning. Your name? So you have a You owe 185, you need time to pay.
Yes,
Do you have anything today?
I have 45 on me right now.
Okay, when can you pay this?
Can I pay a little bit the following Friday and then the rest of it the following Friday?
Sure. How much can you pay on each? I'll tell you what, you pay 45 today. You pay the balance at rate of $50 per week. I'll give you a little extra time, 50 per week, and we'll start that on February the 6th. Is that good?
I appreciate it.
We'll make it February 9th so you can get it here. If you need more time somehow, no worries. Come talk to me on or before the due date, or call the court. Tell them we need to go on Zoom. I'll go on Zoom with you. I'll grant you an extension on or before any due date. I don't care how many times.
Oh, thank you very much. I appreciate it. Times are hard right now.
You know how many people take me up on that, though? They say thank you, and then they don't call instead of, so I don't care if we have to do, I'm just telling you, I don't care how many times we have to do it, all right?
I do appreciate it.
Good luck to you. Thank you.
Thank you.
Mark Daniel Purdy, 25T 645-104. Mr. Purdy, come on up here, sir. Your name?
Mark Purdy.
All right. Illegal firearm transport is the charge. You have the right to an attorney. If you would like one, I will give you one. Would you like an attorney? I'll go ahead and arraign you on January 9 of 26 at 8:39 in the morning. The police think that you were on Medford or Belmont and Trenton, and that you illegally transported a firearm. It says defendant was located inside his vehicle with two pistols in his center console, unloaded, but with one magazine loaded in the center console and another in the glove box. That is a misdemeanor. And in your CPL, they say expired in 2018. That is a misdemeanor under local ordinance, punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty at any time, you will be giving up all those rights, and we are not going to have a trial of any kind. You understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
Not guilty, pleas entered. I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You're not to possess any firearms. No firearms. You're not to possess any firearms. If you have any, you have to surrender those to the police department, Trenton, within 24 hours. And you were printed on this, and also no contact with prosecution witnesses except through your lawyer. Do you understand all of that?
Yeah.
All right, so go talk to him. And I'm going to put this on here. Or you're going to wait outside in the hall, and the prosecutor will call you when he's ready to see you, and then you can come. You're going to come back in front of me either way. Okay. Good luck. People against Alan Fonseca. Which ones do you have?
I have the sentencing on Collins.
I'll call that next. Alan Fonseca. See here?
No,
Lynn
Judge, sorry.
Go ahead. I'm sorry.
The police department just wanted to dismiss that one, so I pulled it.
So the prosecutor wrote up this failure to respond to civil infraction. He sent it in. I can't read what he said, 5 pound or something like that. But at any rate, he's moving for dismissal. Case is dismissed. That's again for failure to appear for a civil infraction. People against Collins, Devin Tyler Collins, 25B149-7738. Good morning, Mr. Schwab.
30720, Mr. Collins.
I also have a B file here. He pled under 7411. That is a possession of a controlled substance, which is cocaine. And he also pled on the drunk driving to the charge of operating while visibly impaired. He was referred for a screening and assessment. Have you had a chance to review that with him? And are there any material additions, corrections, or deletions?
Chance to review with him. I thought that the drug case was marijuana.
Wait a minute. No, I don't think so.
I know you.
They found it prints out possession use of a controlled substance, but this is the one where he acknowledged to the police that he had cocaine in his pocket.
Well, I wasn't the original attorney.
Am I right or am I wrong, sir?
You are correct.
Did I ask you your name yet?
No, thanks, Devin.
Okay, so it was the cocaine. And he was referred for a screening and assessment. Have you had a chance to review the
I have your honor.
report? Any material additions, corrections, or
You
deletions?
just be back, yeah.
Okay, anything that you would like to say on his behalf?
Just your honor, that I believe that he has, tried to address the problem, he's gone to the A meetings, he has abstained from any alcohol and drug usage, he's a working man. It's a little light working during the, winter time, he does catch some things.
Okay,
And, so
he's spending all his money on cocaine though. What's he doing? Go ahead, I'm sorry.
I think that, he's, right now, he's saving a lot of money because he's not doing it.
Well, that's good. That's good. Mr. Collins,
Yes,
what would you like to say? Anything?
Not really, just I apologize for my.
Don't apologize to me, apologize to yourself. You know what I mean? You're a nice looking kid. You seem to have a lot going for you. Get away from that stuff. And the marijuana too, right? I mean, come on. Don't do this to yourself. I hate to see kids like you or anybody, frankly, get themselves in trouble. You just seem like you got a lot going for you, and that cocaine is miserable stuff. Did I let you finish? I'm glad to listen to anything else that you'd like to say.
I do have my 2-month coin from AA. I've
Fantastic.
been going 3 times a week. Basically, ever since the arrest, I've been mostly clean as a whistle, basically up until about 2 months ago. So
Wait a minute, Base. Say that again. The offense was in October. We didn't have a pretrial on this till December 18th. What do you mean? I thought I heard you say I was clean as a whistle up until 2 months ago.
yeah, after the arrest, I was still smoking a little bit, and
I see.
then after about 2 months ago, I was going to stop altogether.
All right. You have proof of your AA attendance? Can I see it?
There's 2 separate ones because I misplaced one of them. So there's a couple on, there's mostly on one of them and a couple on another.
All right. Who do you live with?
Myself.
You own a house? You rent a house?
I live at my grandma's old house and paying off her mortgage right now, living there.
Hey, don't lose these anymore. I'll take it your word. I'm gonna hand you these back. Can you, Mr. Schlaff will hand those back to him?
Yeah.
And he's going to stay out of trouble. I know he is. Right, Mr. Collins?
Yes, sir.
All right. 12 months probation. On file A, it's not under any statute. In other words, there's no 7411 or anything else, but it is on the B statute. So if you're clean, you do everything I tell you to do, that's count 2 on motion to prosecute is going to be dismissed. Because I'm taking it under that statute. You understand that, right?
Yes, sir.
So 12 months probation, all these terms are going to run concurrent. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. I do want you submitting the chemical, kratom poppy seeds and CBD oils are prohibited, by the way. Consuming food or other items containing those substances will be deemed a violation. You're to submit the chemical testing, PBTs and ETGs bi-weekly. The cocaine has me even more concerned than the other. You're going to do that for 5 months. If you're clean, I'll then make it monthly. So every other week, you're going to test, and I expect you to test, okay? We want to make sure you stay off of that. You understand?
Yeah.
All right. 4 days jail, credit 1, serve 3. I'll let you serve all of those on the court work program. There's a $35 a day charge for that for a total of $105. Again, I'm attributing the fines and costs primarily, unless I say otherwise, and all the common costs on file A. So You're also to attend and complete an outpatient substance abuse treatment program. You're going to continue going to AANA 3 times a week until you're in until you're in outpatient treatment. And you are also to attend the Victims Impact Panel. So the quicker you get an outpatient, the better. If you get in this week, you no longer have to go to AA or NA, but you do have to complete outpatient treatment. You do have to attend the Victims Impact Panel. Do you understand everything I've said so far?
Yes.
All right. In terms of fines and costs, on the A file, the impaired file, $300 fines, $250 costs, $75 victims' rights fee, $50 justice assessment, $675. Screening fee is $60 for $735. Probation fees are $240 for $975. You have cost of recovery of $218 for a total of $1193. You have, I'm going to just assess $40 in attorney fees for a total of $1233, plus the court work program fees of $105 for a total of $1,338. I'll go light on your fines and costs on the other case. It's simply going to be 100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. The screening fee, probation fees, cost of recovery fees are all going on the A file. So you owe $325 plus $1338. That would be $1663. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge, certainly on the impaired, and the prosecutor certainly can move to dismiss the 7411 if he is satisfied once you file your motion for early discharge on the A file.
Your Honor, if I may.
Sure.
Is it possible for him to do some extra community service in lieu of some of the costs?
You can't pay these fines? I mean,
during the winter, I work like a part-time job because my job is seasonal, so.
here's what I'm gonna do.
After the time during.
I'm gonna let you pay $50 a week. And I'm gonna do that on the A file. And I'm gonna start that beginning on February the 27th. I'll give you a little bit of leeway time. So I'm gonna only have you pay $50 per week starting that date. If you need more time, you can come talk to me. After you pay the fines on and costs on that, you're gonna pay on the B file. So after fines costs paid on the A file, you'll pay them on the B file. If you're really running into trouble, you come back in here, file a motion. I'll be glad to entertain that request for you, okay? I'll give you a review hearing date right now, which is going to be 12 months out on the 7411, the drug charge. What do you have for me there, Amy? It should be in January of 27, God willing, if we're all here, Mr. Sloth.
Very good.
It's going to take her a minute. That's the next year's calendar.
January 27, we can do the 14th.
14th is good. January 14th at 8:30 in the morning, okay?
Yes, sir.
Now, that's independent of the other case. So if you do everything, there's no violations, you feel free to make your motion for early discharge in 6 months on the impaired charge. And usually the prosecutors will then go ahead and dismiss, move to dismiss on the other, okay? I wish you well. Thank you, Mr. Schlaff. You're going to meet with probation before you leave here, okay? Thank you.
Let's switch it up. We'll stay in Michigan, but let's go see what's going on with a certain Judge Simpson who's getting his day rolling.
Come on up. Oh, somebody. I need.
Right. We're starting strong.
Yes, we are.
Your Honor, Ms. Cannon is having some stage fright. Michael Getty from the Washington County Public Defender's Office. Your Honor, to the extent that there's a conflict, we would waive any conflict. Once we agree with the prosecutor, we'd ask the court to waive any conflict or any potential conflict or thought of a conflict in these matters.
And the court, for its part, does not believe there's conflict either under Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Kenyon Jackson.
Al Chavalowski for the People.
David Eichelstein, appearing on behalf of the defendant.
All right, Mr. Jackson, can you state your name, please?
Hey, Al Jackson.
Thank you, sir.
Your Honor, Mr. Chabalowski and I have had an opportunity to discuss these matters. This matter is going to have to be sent, these matters are going to have to be sent to circuit court for resolution. My client was unaware of that because he's in the Macomb County Jail. But Mr. Jackson, we're going to work out a deal for you in circuit court, just like we did in Macomb. So we need to waive exam, just like we did in Macomb. Is that okay with you?
Yes.
All right. So, Mr. Jackson, you understand that you're waiving your right to have a preliminary examination in these matters?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing on these matters and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all charges.
Your Honor, we acknowledge receipt of informations in both files. My client waives the reading, stands mute, asks that a not guilty plea be entered.
Trying to find the case. I have 4 counts on the case. I have 4 and 3, correct?
Correct.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 7 counts. Pretrial in this matter will be set for
February 23rd at 1:30 before Judge.
February 23rd, 2026, 1:30, Judge Hamud.
Sorry, Judge.
Hamud.
I thought you said Judge who?
I did not call
It's
it.
going to be one of those days, Judge. It's going to be one of those days.
All right. Bond will continue.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Demarion White.
Sir. Morning, Your Honor. Please summon court David Burgess on behalf of Marion White, who's appearing via Zoom from the Juvenile Center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are working toward a resolution. It's probably going to get bound over eventually, but we need a little more time at this level. So we're just asking for a couple weeks adjournment, Your Honor.
Returning to 12. All right. Probable cause conference will be adjourned to February 12th.
Thank you.
2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you, sir. Court calls the case of the people versus Margaret Patowski. Yeah. Patowski? Yeah, she's in Zoom, I think, but I need an attorney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Patowski.
Ms. Patowski, can you state your name, please?
So I'm muted. A case law in there, because everything else was.
Ms. Patowski, can you state your name?
Margaret Petoskey.
Thank you.
There you go.
Your Honor, there was an offer
Thank you.
made in this matter, and I did meet with Ms. Patowski at the Department of Corrections yesterday, and as soon as I left the department, was able to leave the department and get to my cell phone, I did reach out to Mr. Childers to let him know that she intends to accept the offer. Unfortunately, I don't believe he received it in time. It was like 4 o'clock, although I had a 1:30 appointment.
I'll then adjourn this out 2 weeks to the 12th, February 12th, 2026, 9 a.m.
And I apologize, Ms. Patowski. I know you.
Bond will continue, and hopefully then I'll have the paperwork and we can get it all settled. Okay, Ms. Patowski?
Okay, thank you.
All right, thank you. Court does call the case, People versus Procopio Vitale.
Your Honor, Raymond Cook with the people. On behalf of Mr. Vitale, good morning, Judge.
Good morning.
Mr. Vitale will be approaching. Please state your name for the record once you get up here.
Procopio Vitale.
And if you wouldn't mind signing here.
What are we doing?
Your Honor, today's date and time set for probable cause conference. We will be waiving the preliminary exam at this time. Mr. Vitale is executing a waiver form right as we speak. And it to Deputy Allen.
Is that correct, sir? Yes. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute as to reading or waive. I got there eventually.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for February 12, 2026, 1:30, Judge Slay.
Okay, thank you, Judge.
Bond continued. Thank you. Calls case of the People versus Tiffany Peters.
Go on behalf of Ms. Peters. Judge, it's the attorney AG case.
I think it's an ADA case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Judge, this is a PCC matter. I had a long,
Want to state your name?
oh, I'm sorry, Robert J. Kill on behalf of Ms. Peters. Sorry about
Ms.
that.
Peters, can you state your name, please?
Tiffany Comer Peters.
Thank you.
Judge, Ms. Peters is living in West Virginia now. This is a child support matter. She's current in her payments as far as monthly payments. I'm asking for a 30-day adjournment. Again, I had a long conversation with her last night. She can make between now and then, within the next week, she can make an $800 payment. And we're hoping she can bring this amount down to where we can work this out short of a felony, but we need some time to do that.
Going to be any objection from the people regarding that?
No, I would just like the attorney to get in contact with our office, but no objection, Your Honor.
Going to call their office?
If I know who to call. Yes, I will, Judge.
Thank you. Probable cause conference will be adjourned then to February 26th.
Thank you.
Thank you, Judge.
2026.
Thank you.
9 a.m. Bond.
Thank you. Appreciate your consideration.
Court calls the case of the People versus Gary Carmichael.
David I. Goldstein, appearing on behalf of the defendant. State your name, Gary.
Gary Carmichael. Thank you.
Setting this matter for exam, Your Honor. I do have all the discussion.
That's right. People have their witnesses available to 10.
Your Honor, I'm going to be gone the month of February.
The whole month?
Yes.
That's right. He held on something else?
No, Your Honor. I was going to make a bond motion in a moment, Your Honor, but
People going to be opposing a release in this case?
I would just ask for a tether as well as a potential silver.
Okay, here's what I'll do. Will March 3rd work for you?
Your Honor, I've got a trial starting on the 2nd. I can do the 10th.
All right. So what I'll do is preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington. What I'll do at this point is I'll have his bond continued. You two send a stipulation over with the conditions and then I'll sign off.
All right, thank you.
All right.
Thank you.
Thank you. Court calls the case People versus Randall Laird. AG case.
Morning, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dottie Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
You're going to be requesting an adjournment. I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that other one page you guys. 26. Yeah, so let's go that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Mr. Patton, can you state your name, please? Just Mr. Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That's correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, sir.
And that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, sir.
understand that? Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
At 8:30 before Judge Perry.
February 27, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
He was the first.
Are you gonna be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're gonna have to find a way to.
I can find a way.
to Test. Because if I let you out, we're gonna end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated. with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you. That's what I need to do. CC. Just want it put back to her. Court does call the case, People versus Michael Padola. Yeah, I see him. Who's his attorney? Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedola.
I'm gonna pass your case. We gotta wait for your attorney to show up.
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena Self.
I'm sorry, did you call Bedole? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court. Kadena Gill Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th,
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see, she does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond, we requested 25,000 cash. Period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver. He had 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to this car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe, or additional charges, calling someone names isn't enough.
Well, the
But as for that's,
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything.
just
Motion for
addressing-
bond reduction denied. Bond will continue. Thank you.
Morning, Your Honor. Your Honor, John Gold, piece 30758, with respect to incidents between name on the record.
Nicole Weems. Okay, thank you. And today's date scheduled for probation violation on your client's case on 25410A. And then it's set for sentencing on your client's plea to an amended charge of operating while visibly impaired, which was reduced from a high BAC on case number 251269. And counsel,
Your Honor, as to the probation violation, I have discussed it with Ms. Weems. In fact, we discussed this at the time of the entry of the plea on the 2069. The violation is that she picked up a new case while on probation. She is guilty. In fact, you're sentencing on that matter. And we'd ask that the recommendation be adopted.
okay, so, is this something that is your client maybe interested in a treatment court, counsel? Have you spoken to your client about that?
No, we have not.
Because we could, there could be both referred over there. There's not as much time on her original charge, on the 25 case, however, or the 410 case. Your client's on probation for possession of controlled substance, and then she
Correct.
picks up a charge for high BAC at a 0.184.
That is
And one of the conditions is not to possess or consume any alcohol or drugs unless prescribed. And, is that,
You're right. I think that she has been going over probation here with this court regarding the original matter. She's also been very cooperative in understanding that I've spoken to Miss Shine previously when the violation as well as the sentence report was provided to me. Taking all those steps, she's got a new job. I feel that at this point in time, Your Honor, I don't think that she realizes that you cannot use any type of mind-altering substances. She, everything she's supposed to respect to be with sentencing other than picking up the new case, and I understand that. I'm not making light of that. I don't see that the specialty court would be appropriate under these circumstances.
okay.
I mean,
Given that your client's on probation for a possession charge and then she picks up a high BAC charge, I thought that perhaps there might be something that she wanted to explore regarding, sobriety court. But okay, as to this, let's handle the sentencing first. As to the PSI counsel, do you have an opportunity to review the PSI with your client?
that is correct, Your Honor. There were no additions, deletions, or corrections made at this point in time. As the report indicates, she's presently employed at E-Funds in Southfield as a life insurance agent. That's a new job that she's been with now. How long?
Like 2 months.
About approximately 2 months. Clearly, she's trying to better herself. Is taking all the steps necessary to do all that. She's been clean on her other probation matters. There are no other violations. In other words, she's not missing tests. She's not testing positive for any controlled substance. She's on an alcohol tether at this point, and there have been no violations on that as well. We're asking the recommendation be adopted.
And so tell me about your warrants, ma'am.
The warrants that I have through Wyandotte still, I've been working on paying for my probation fees and paying off those slowly as much as I can.
What's the status of your driver's license?
It's valid, but it's restricted due to the OWI.
Okay, well, there aren't any warrants in Wyandotte. Do you have a warrant out of Novi for failing to appear for retail fraud sentencing.
Oh, I wasn't aware of that one. Is that old? Does it have a date on it?
2020.
Oh, okay.
You don't remember anything in Novi? You don't remember pleading to a case in Novi?
No, I never went to court.
You never went to court?
No, that's no bad. But I can take care of that too if I'll go down there and see what.
Well, this appears to be you. You don't remember being charged for shoplifting from 2018?
No, I never went to court for anybody.
Well, it claims that you didn't appear for sentencing, so at some point you must have attended court to plead guilty.
Right, I'll have to look at, I'll take care of that one. I wasn't aware of that one.
Okay, and then you also have one out of the 34th District Court for something from Van Buren Township.
Okay.
You failed to appear for driving while license suspended. So there may only be 2 warrants, not 3. If you're a test right now, ma'am, what's in your system?
Nothing.
And how old's your son? 7? Yes?
Yeah.
Okay, well, you really need to get all these taken care of, ma'am, because you certainly don't want to be arrested when you have your son in the car.
Right.
So. All right, as to the charge of operating while visibly impaired, the court's going to find, after hearing from counsel, hearing from Ms. Weems, reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court's going to also order that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Weems. The court's going to order 18 months probation. You're eligible for early discharge. I'll go over that shortly. Some of these are going to sound familiar since you're currently on probation. The court sentenced you to some of that already. Not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms so you can maintain sobriety and prevent relapse. The court's going to also order you to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. You're to participate in the fan meetings once per month. The rehabilitative goal for that condition is so you can have additional support in maintaining sobriety as well as recovery resources. The court's going to also order 7 days on the court workforce. The rehabilitative goal for that condition is so that you can further develop life skills to give back to the community and you are to clear up your warrants. Any questions as far as those conditions? Court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Workforce is $280. That's $50 a day, $40 a day at 7 days. for a total of $2,005. You did post a bond, so you can apply that bond. You can work out a payment plan through probation. And I did indicate you're eligible for early discharge as long as all the following apply. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been paid in full, or you made a good faith payment for making full payment. So let's handle the probation violation now. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the allegation, ma'am, and as to the allegation that you violated probation with your charge that you were just sentenced on, how do you plead?
Yes.
You've gone over your advice of rights for probation violation purposes, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand the possible penalty as a result of your plea. The recommendation is for you to continue and complete all terms of probation, have under advisement status revoked, pay a $50 probation violation fee, and additional workforce days, increased testing, and 10 days jail. You understand that's the recommendation? Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? I'm sorry?
No.
All right, counsel, if you can please report to your client.
Thank you. Ms. Weems, you were placed on probation to this court. Is that correct?
Yes.
And one of the terms and conditions of probation were that you were not to pick up any new matters. Is that correct?
Yes.
And in fact, you did pick up another matter, and it was actually in this court as well. Isn't that correct?
Yes.
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And not only were you not to get violate any criminal law of any unit of government, but you also were not to possess or consume any alcohol or drugs that were not prescribed, correct?
Yes.
All right. The court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Counsel, as to the recommendation.
Your Honor, Rita, other than the revoke of her under advisement status, I have discussed that recommendation with her. She understands the severity of what occurred, and we're asking the recommendation be adopted, except for the fact that she loses her under advisement status. There is no, and we've indicated, there was no, well, she picked up a new case which dealt with alcohol, and I agree. She has been going to her classes. She's been taking care of all business on that matter. She's been on an alcohol tether for a period of time. We feel that she did not lose her under advisement status at this point in time.
Why not?
Because, Your Honor, this was a slip. She now being punished for her consumption of alcohol as well. And for those reasons, Your Honor, it will even do a greater, as you heard, our driving privileges are restricted to from court, et cetera. And if this under advisement status is revoked, then she'll be losing her driving privileges for a period of time because this was a drug-related offense. And she just got a new job. Has children child that she has to take care of. And the loss of her license at this point in time would only create, it's our own fault, further hardships to successfully completing both terms of.
Okay, so let me ask a few questions, Ms. Weems. You recall at sentencing on your possession charge that there would be mandatory jail for any violations, correct?
Yes, I do remember.
And in fact, you received that in your written order of probation.
Yes.
And I also understand that you lost the other job when you were in custody, correct?
Yeah.
So then knowing all of that, ma'am, why would you risk any of that and violate probation?
Yeah, I just don't, I really don't want to lose.
That wasn't my question. That wasn't my question. My question is, why would you jeopardize that?
I definitely made a mistake. I didn't mean to. It won't happen again, but I don't want to hear again. I don't want to do this again at all. And I definitely don't want to lose the job that I have now. It is very good. It's a good job. It's good people, good pay. I want to be able to pay my fines to the
Well,
court.
and all that's great, ma'am, but you're still not answering this court's question. Why did you jeopardize your status and violate probation? And you didn't just, wasn't just a slip, right? Because you consumed a lot of alcohol. You were 0.18 something. That's a lot of alcohol. It isn't just one slip where you forgot to call for drug testing or, you know, you had a sip of somebody's drink or something like that.
Right.
You consumed a lot of alcohol.
Right.
You made the conscious choice to violate this court's order and jeopardize your freedom. Why would you make that choice to jeopardize your freedom?
Because I don't really have a better reason other than I was just being stupid. And I don't plan on doing it again, but it was very stupid and I was just not in a good place and being stupid.
Well, your probation officer has a much more bleeding heart than I do, because your probation officer is recommending to suspend the jail.
Yeah.
Despite this court's order indicating mandatory jail for any violation. And I also, when I sentenced you in May, ordered you to clear up your warrants. And we're 9 months into your probation and you haven't done that yet either.
Yeah, I wasn't aware of the November. I'll take care of that one for sure. I got the Allen Park one taken care of. I know that was some of the ones I had. And then the Van Bureau one I can do as soon as I get paid again.
If you were to test right now, what's in your system?
Nothing.
And is it just you and your son that live at home?
Yeah.
Yes?
Yes.
The court will suspend your 10 days jail. You are to have additional days on the workforce. You're to increase your testing. Do you currently have a tether?
Yeah.
A $50 probation violation fee. You'll continue and complete all terms of probation. The court will continue your under advisement status at this point. If you are back in front of this court for a violation on either of your cases, ma'am, you can be sure of one thing. Well, two things. You will be serving jail time and you will be losing your under advisement status.
Understood.
going to also order 30 days on the alcohol tether. So while it may be ending on the matter you're just sentenced on, you will have it on the probation violation. I'm not going to add workforce days.
I'm sorry.
I'm not going to add additional workforce days.
Okay, thank you.
Tether instead
Thank you, Ron.
of increased testing. Okay, ma'am, please have a seat in probation and Ms. Shine will be with you shortly.
Thank you, Ron.
Good luck to you. Let's go off the record for a moment.
Okay, is there a prosecutor maybe on this one?
Who's this, Jeff?
Gregory Renfro? This one's Daniel Boyd. You filed a motion a long time ago. See, I don't even know the facts right now, but I'm looking at this and something doesn't smell right at all in all of this.
I didn't see him on my docket, but I guess it's.
Something doesn't seem right at all here.
Okay.
Okay, we have a motion to revoke
Okay.
probation that was filed on October 2023, over 2 years ago. Was the defendant? Anybody?
I don't know, Judge. This was not on my docket. I'm trying to look and see.
It was added late yesterday, but.
That's
because
I know that, but I've done this long enough. Something is not right here. I'm just looking at it for the first time, and a motion was filed over 2 years ago. He's on regular probation for all things evading detention with a motor vehicle. And something tells me that he had absconded for 2 years and had been on the lam. But can somebody figure, there had to be a warrant issued for his arrest on or about October of 2023, over 2 years ago. And it looks like this is some.
Information shows he was arrested December 16th, Judge, so he would
Of
have had.
what?
Of
What year?
2025, so he would have had to have been an absconded. I gotta just could get it.
Yeah, well, that's not good. If that's true, I'm gonna let you out.
Well,
Why would anybody in their right mind do that? If he had compassion, I got compassion. What he doesn't have is rule following. He was on regular probation. He had been convicted for, of all things, evading detention. So we filed a motion, so he evaded answering to the motion for over 2 years. So they caught him somehow, and now he wants to get let out.
I don't know how the circumstances of him going into custody or
Well,
whether he,
why wouldn't you know that? You're representing him.
I haven't had an opportunity to.
Well, I've just pulled the
we
file
can
and looked
listen.
at it, and I think I can, this is simple enough to figure out. This is just math.
Why didn't you report? Did you not
It-
report for that time period?
Wait. You're gonna ask him things. Raise your right hand because you're under oath. You solemnly swear or affirm any statements that you make during this hearing will be the truth, the whole truth, and nothing but the truth, subject to perjury. So help you God.
Yes, sir.
Lower your hand. Go ahead.
Mr. Renfro, there appears to be a period of time where a motion to revoke probation was filed and then around 2 years elapsed before you were taken into custody. Were you reporting during that 2 years in the previous position?
You were reporting it first, Mr. Harmon, Gary Harmon?
Yes, sir.
Who's the probation officer on this one who can answer for this? Because he's saying some things and I'd like the probation office to tell me what is accurate. Because I don't rely on this. I'm not gonna rely on him. Anybody, somebody's gotta be here.
It's not on the document, that's why nobody.
Oh, he got pulled at the last minute?
Yeah, he did
He files a motion just yesterday.
Because of the street,
Like some states docket.
because of this mother's funeral. I mean, I'm not, you only have one mother in this world, and when she dies.
You're telling, what are you preaching to me
I'm not
for,
preaching,
sir?
I'm just saying that's my reasoning is trying, I understand that I'm trying, putting the district attorney's office and perhaps everybody at a disadvantage doing this at the last minute. But the exigent circumstances that we only have, I mean, to try to go to this mom's funeral.
Consider rhetorical language. Just tell me what the facts are. That's all I need. You know, you don't have to tell us all we only have one mother.
Well, I'm saying as far as my reason to try to accommodate Mr. Mercer, irrespective of his.
But think of this, what you're going to have to answer is the question of, number one, he's on evading. Number two, he absconded for 2 years.
Well, that's what I'm sorry.
And you can interrupt, I guess, all day long like you have done historically, and we're not going to get anything.
Let's attempt to explore the reason.
Can we just speak one at a time? You all, you know that the court reporter can't take both of us speaking over each other, please. So that's what needs to be answered, is not that his poor mother passed away. My God, my mother is very ill. So I'm not non-sympathetic, but what I have is looking at the circumstances here. He's on probation. We placed him on probation. He pleaded guilty and he was convicted for evading arrest or detention. That is fleeing. Then for 2 years, he fled from probation and he had been an absconder for 2 years.
That's what I was attempting to explore.
Can I finish by, this was a solo I was performing. Let me just conclude it. So he absconds, and when was he arrested?
December of 2025.
All right, just last month. So just last month, he was finally arrested after 2 years and over 26 months of evading responsibility. So you can see the concerns this course has. What in the world can I possibly have as a guarantee that he could be released and come back? No, he started off this case. He got in trouble for evading and running from the police when he was supposed to stop. Number two, for two years and 26 months, he's been evading and fleeing his responsibilities. We caught him last month, and now you're asking for him to be released on his own word that he will report back. You can see where that's going to be a tall mountain to climb. Go ahead, you may speak.
What were you doing the last 26 months between the time the MTRP was filed and December?
I was in Rose at Lamar State College Port Arthur for.
You weren't reporting as ordered by the court.
My probation officer, Mr. Gary Harmon, he had retired. And then transitioned to somebody else, and never let me know a new day. And Mr. Harmon informed me to not come up there and report, was they would take me to jail. He said, keep reporting over the phone. That's what I was doing. Now I went to college, I didn't start a business on my own. It wasn't just running, I've been doing productive things.
You stayed at the residence you've been at since you were on probation.
Yes, sir.
Stayed at that residence.
Yes, sir.
Has any attempt, was any?
Please, Gator Harmon, where is he? I know, but is he still in the Beaumont area?
No, he's in Houston, sir.
Okay.
You were.
My term of my probation.
If you think I'm going to take your word without substantiate, you won't. You're going to lose every time with me on your facts. You cannot be trusted by your history, criminal history. You cannot be.
Not procedural.
Go ahead.
If the court were to see fit to allow you to be released from jail, either by posting a bond or have means, what guarantees could you provide to the court that you would return to custody after having your ministry? How can you assure the court that you would return to custody once you obtained your mother's treatment?
What do you mean by that?
Well, how are you going to represent to the judge that you're going to go back into custody after you attend your mother's funeral if he lets you out?
Yes, I definitely will.
You want to get this straightened out?
Yes, sir.
Where I know.
Yes, sir.
You didn't leave the state or attempt to go anywhere.
Awesome. probation officer told me to try to pay all my fees off and then turn myself in. What I've been trying to do. I never smoked to.
Are you through? You through?
Yes.
Well, let me tell you what Gator Harmon actually said. On September 14th, 2023, that caused this motion to revoke for 2 years. That you have been AWOL for 2 years. On September 14th, 2023, the defendant failed to report to the criminal district court as summoned. So there we go. You didn't report to the court as you were summoned to do. You failed to report to the probation office for a scheduled visit, alleging medical issues. At this time, the defendant has not produced any medical documentation concerning his absence. The defendant has not made any effort to address his delinquent court-assessed fees since February of 2023, as ordered by the court. It is therefore requested that a motion to revoke probation be filed. He recommended it. The man you're saying was letting you do all of this. He recommended and urged the motion to revoke probation. It was filed and a warrant had been issued for your arrest, and we finally caught you after 2 years.
I missed court because I had COVID. I sent my form in to some later, Miss Ellie. I sent to Mr. Harmon. He received both of them.
Failed to report, asked him to produce medical issues, medical documentation concerning his absence. Never did. And here you are, after 2 years, we finally caught him. Anything else?
I just asked for the court to exercise some compassion and allow me to attend the funeral of his mother. Obviously, if he doesn't report back, then that would not bode well for the court's disposition of the MTRP in any sense.
It's not going to, no, we've got him right now. We've got him. It's what has been done doesn't bode well for his disposition, but we're not letting him go on my watch. Now that we caught him after 2 years.
No, I don't know that he was taking active measures to obey, Your Honor.
He was taking active measures not to report as required.
And I don't think that he was.
If you don't report, you're not on probation. And what's good for you is good for the other 5,000 probationers. If you can just scamper off and decide when you want to report or what terms you want to set for yourself, it's good for every 5,000. That's what's fair. We're not going to treat you differently. You're supposed to matriculate into the group. That the first thing you do is the first order. You must report as required. Otherwise, you're not on probation. You're on your own probation, which isn't the way it works. What does the state have to say?
Judge, as compassionate as I am and would like for him to attend, there's just.
Yeah, nobody thinks this is, I feel sorry for the family, but not you. I mean, this is, you can't not be trusted.
If it was years ago, we used to do a furlough where they would get a furlough, but they would have to pay a deputy sheriff to escort them from the jail. They would have to pay for his time to escort him there, stay for the funeral, and come back and pay for his salary. And that was the only way we would do it back when they had a conviction like this.
How did you get arrested?
Coming from work.
Traffic stuff.
That warrant was only out for 2 years.
I didn't even know about it.
I don't care what it's not what you know or what you say you didn't know. The fact is, it had been an issue for good reason. And you, for whatever reason, they had not been able to catch you until 2 years later. But we're certainly not in a position to let you go free. Not under what you're charged with in the first place, which was deceptive. And now with you were convicted, sentenced to 10 years, right? Yeah. Sentenced to 5 years in prison, probated for 10 years. So you were convicted. And then your statement about Mr. Harmon is completely different for what Mr. Harmon submits in this administrative report that caused the motion to revoke probation. And I don't see anything in the file that states him asking to refute or to withdraw his statements or this motion that he asked to be filed. And without anything else, sir, I'm not granting the relief.
I was just gonna add, Your Honor, if the court was looking for some assurance that he would attend a subsequent hearing, then obviously if he misses his granted bond and post bond and he willfully fails to appear at the next court setting, there's a bond jumping statute that will be filed, and that will be one level above what he's on. This, what the case is, which will be a second degree, so he would expose himself to 2 to 20 years incarceration if he didn't. Versus just the 5 that he's exposed to now.
Stay asking.
I don't have an objection to a bond being set, Judge, but we'd have a GPS monitor on him, so we'd know where he is.
And of course, if he doesn't appear to the setting.
Hold on, what is, is this what we do? We're gonna open this door right now, after 20 years here, we're gonna open this door and say that he is allowed on his own, on his good word, which he has defied twice?
I'm just saying, the court asked what incentive or what assurance the court would have that he reappears, it would be his exposure to 20 years in the.
Well, that was what he was exposed, he was exposed to criminality, additional criminal sanctions in the first place. That didn't deter him.
I'm just, he would be exposing himself to an additional,
So
it
the
would be
state
a
is saying,
consecutive sentence to
are you stating you have no objection to releasing him under this?
Not saying just releasing, Judge, but under certain conditions.
What conditions?
Well, my first suggestion, I think, was always the best way to do it, which was they make arrangements with the sheriff's office to have a deputy take him out of jail and take him to the funeral and bring him back. That's the way you know that he's still in custody.
There is no way he's going to pay for that.
The family would, Your Honor. I don't know if the sheriff's department still does that. So
Yeah.
I don't think they do that.
Well, why don't you figure that out?
The only other way.
I'm not going to.
Oh,
I want you to.
They don't do that.
Sir, I don't think they do. Okay, so let's say they don't, then what?
Close to what he.
If they don't do it, what does the state say?
Have a bond and GPS. And set it next week for a disposition. You got a short reset. I mean, it's a failure to report. It shouldn't be too hard. Or having pleaded true to it now and set it for sentence.
What difference would that make? He would abscond and abscond.
Well,
If he absconds, that pleading true doesn't make a bit of difference.
If he absconds, he's exposing himself to a 20-year consecutive sentence on top of just the 5.
That, this sort of stuff has happened. This is the situation that's happened before. When has that ever been done?
Not bond jumping?
Where it's been filed like that? You can't even recall it. And
I think Steve Better was the last one.
All right, if there's no objection to the state, from the state, then yeah, okay. He's allowed release.
From how much of a bond?
Well, do you have any money to pay for a bond?
Yes, my family does.
How much?
I'm gonna say I haven't talked to anybody today or yesterday.
Well, it's 3rd-degree felony. He's looking at 10 years he was looking at 10 years in prison in this. So $5,000 bond. He says have a GPS device as a condition of bond. And he has to report back. He has to report back immediately after the funeral. Yeah.
Okay, you understand? But if you don't, I want to put this on the record too, that if you don't, and something goes amiss here, you know, he missed your next school day, they're represented there and file a bond jumping case with your exposure to 20 years consecutive to this. All right, you understand?